Good afternoon, ladies and gentlemen. Good afternoon to our participants and panelists from Aruba, Curacao, St. Martin, and other islands. And a good evening to our participants based in the Netherlands and even Belgium. My name is Steven Damiana. I am from the Curacao Chamber of Commerce and Industry. But in this setting, I am representing Europe Direct Curacao as a local manager based in Curacao. I would like to welcome you all to our fourth seminar, our webinar on the Dutch Kingdom, Treaties, and EU law. Before we start, a couple of house rules. All our panelists will have their presentations, and at the end, you will be able to post your questions. To pose your questions, you can feel free to start writing them down in the Q&A section after each speaker finishes their presentation, so you don't forget what you were going to ask. Our panelists will then answer them after all presenters have performed their presentations. If you already know who you wish to ask the question, please state the name of the presenter and the question in the Q&A section. The session will be recorded and will be eventually posted on the social media of Europe Direct Curacao. I would like to pass the floor now on to Mrs. Ruth Bonneval of the University of Aruba, partner in this webinar with Europe Direct Curacao, for opening remarks.
Stephen, thank you very much for this introduction. Good afternoon, dear ladies and gentlemen, panel members, colleagues, students. I would like to welcome you all to this webinar, The Kingdom, Treaties, and EU Law, organized by the University of Aruba and Curacao in collaboration with Euro Direct. My name is Ruth Bonneval-Kok, and the Dean of the Faculty of Law at the University of Aruba. On this rainy, or now it's shiny, afternoon in Aruba and an autumnal evening in the Netherlands, I have the honor to open this webinar as an alternative to a live seminar that we used to have in the tropical garden on the beautiful passes of the University of Aruba. We offer this webinar for all interested parties from all over the Kingdom of the Netherlands so they can participate, and for which I especially thank the initiator of this webinar, Mr. Request, who came up with this initiative. I am very pleased that the University of Aruba and the University of Curacao are organizing this webinar together. The topic for this webinar is based on the recently published advice of the Dutch Council of State on the Kingdom, Treaties, and EU law. Questions arise such as, how are the Dutch overseas countries and territories involved in the conclusion of treaties within the Kingdom? How are the legal frameworks on the subject being applied in practice? These and other questions will be discussed by three speakers consequently. First, Mrs. Samira Rafael, Europolitician. Secondly, Mrs. Mildred Schwenner, State Counsel for Aruba. Thirdly, Mrs. Viola van Boogaert, an expert lawyer in the field of European and international law. Participants will be invited to engage in an in-depth discussion on these themes. Output of this conference will be posted on the platform of the Conference on the Future of Europe. The Conference on the Future of Europe is a unique and timely opportunity for European citizens to debate on Europeans' challenges and priorities. And by spring 2022, the conference is expected to reach conclusions and provide guidance on the future of Europe. Today's webinar once again shows the collaboration between two Caribbean universities. The University of Aruba would love to continue this trend more often in future on various topics. You can stay informed about these and other activities of the University of Aruba via Facebook and Insta, so please keep following us on social media. On behalf of the University of Aruba, I wish the panel members, the moderator, and you as participants an interesting and fruitful webinar. I'd now like to give the floor to Mrs. Samira Rafaela, who will give her introductory lecture. Please go ahead.
Thank you very much, and thank you also for your introduction, a very important topic that we have to discuss. And I am pleased to be here with you virtually for this webinar discussing the Kingdom, Treaties and EU law. And the advice by the Dutch Raad van State gave the inspiration for this webinar, for which I especially want to thank Mildred Schwenner, who worked on this advice with her colleagues. And although I'm not officially trained in law, the functioning of the EU and EU law is something a member of the European Parliament must learn to be effective in the European Parliament and in the EU. So as a general remark, I can observe in my daily work that most persons working in the EU have a solid, grounded background into how the EU treaties are constructed and how EU law functions. And basic knowledge of EU law is, of course, very important when working in the EU bubble. And you need to be able to know what implications your policy choices for the eventual legislation coming out of the EU legislative process are. And the EU bubble has a solid grounding in how the EU as an institution functions on the European level. However, knowledge and sensitivities of how the relationship of the EU and overseas countries and territories is shaped is not always present in the EU. Due to this lack of knowledge within the EU, officials working, for example, for the European Commission are not entirely aware of the effect decisions have on the ground on the overseas countries and territories. And at times, I, as Dutch member of the European Parliament, who aims for better representation of the overseas countries and territories in the EU, hear that certain competences lies within the Netherlands, while the Dutch state points to Brussels. And this confusion of competences affects the opportunities the overseas countries and territories could explore when it comes to cooperation with the EU on multiple levels and topics. And we can take, for example, the Venezuelan crisis, the subsequent migration flows and the wider impact on the region as an example in this regard. And within the EU, we were discussing how we could effectively support countries affected by the Venezuelan crisis. And many discussions focused on countries such as Colombia, which many did not take into account that Dutch overseas countries and territories are affected as well. I worked on making more financial assistance available for the Dutch overseas countries and territories. However, the European Commission referred to the government of the Netherlands as this is a national competence in their view. And this difference of power and the absence of abilities must be addressed. And in my view, this shows why we need to keep developing and expanding the understanding of how the overseas countries and territories should be included and how they could contribute to common goals on the European level. So there are many people on the EU level who mean well and want to find holistic solutions for issues such as the Venezuelan crisis. And advancing the interest of the overseas countries and territories on the EU level can naturally take many forms. So back to the Venezuelan crisis, we need to ask ourselves the question, if the Netherlands, the overseas countries and territories and the European Union speak on the same basis of understanding when addressing certain issues like this crisis, but definitely also other issues. So additionally, improvement of the situation can only occur when parties develop a dialogue to hear and see others' position. And this is especially important for young people in the overseas countries and territories. And there is not only a role to play for the overseas countries and territories themselves, but also for the Netherlands Permanent Representation and the Overseas Countries and Territories Association, OCTA. And by coming together and collectively advancing common interests and goals, such as mitigating climate change or ocean governance, the overseas countries and territories and EU can work on the basis of a mutually effective partnership. And because of the nature of the relationship that the overseas countries and territories formally have within the EU treaties, the relationship is at times complicated and challenging. But the awareness of the status of the overseas countries and territories is progressing in recent years. In September, me and my colleagues in the European Parliament voted on the new Overseas Association decision. With the new decision, the EU moves away from a development-oriented approach towards an approach based on equal partnership with the overseas countries and territories. And the decision is, in my view, a new step into the right direction for better association of the overseas countries and territories with the EU. A relationship that is based on the development of a robust partnership that is grounded in cooperation with and social and economic development of the overseas countries and territories. And since I started my mandate in the European Parliament, the discussions within the EU developed as well. I myself am committed to bring the relationship forward, and together with my Liberal colleague, Stéphane Bijou, I founded the Friends of the Overseas Countries and Territories group in the European Parliament. And with this group, we want to advance the interests and position of the overseas countries and territories within the EU bubble. And together we engage with the European Commission about the strategic importance of the overseas countries and territories to develop a more cooperative approach. And the European Commissioner for International Partnerships, Jutta Urpilainen, shows commitment to the specific role of the OCTs and how we can collectively bring the relationship forward. And in the exchanges me and my office have, we see a real, genuine interest in the OCTs. So I want to keep reminding the European Commission, but also the European Union in general, that it is very important to develop the strategic partnership with the OCTs, taking, of course, into account also the effect and the impact of new policies and legislation, taking into account the competences, of course, but it is clear that we have more opportunities to work on a better and strategic relationship with the OCTs. So I would like to thank you again for inviting me as a guest speaker for this webinar, and I look forward to hearing from you. Thank you.
Thank you very much, Ms. Samira Rafaela. I'd like to pass the floor now on to Germaine Request, my colleague of Europe Direct Curacao.
Yes, thank you, Stephen and Damiana, and also thank you, Mrs. Rafaela, for your opening speech. My name is Germaine Request, and I am the manager of Europe Direct Curacao. I want to tell you some short, a few words about Europe Direct Curacao. It's an information center that belongs to the network of the official information centers of the European Union, which has almost 500 centers across Europe. The information center answers questions about the EU, its institutions and policies and funding opportunities, promoting political debate at local and regional level. Europe Directs are an important link between the EU institutions and European citizens. Since May of this year, the Europe Direct Curacao Center is now located at Curacao Chamber of Commerce and Industry. Europe Direct Curacao is the first EU information center in the Caribbean region. The center organizes EU events in close collaboration with the University of Curacao and also with the Curacao Chamber of Commerce. The establishment of Europe Direct Curacao is financially supported by the European Commission, the Executive Committee of the European Union. Ladies and gentlemen, please join me in welcoming our next guest speaker, Mrs. Mildred Schwenner. Mrs. Schwenner is a former attorney at law and partner of a firm with offices in Aruba, Curacao, Bonaire, St. Martin, and Amsterdam. Mrs. Schwenner left practice in 2017 to serve as a state councillor, a member of the advisory division of the Council of State of the Kingdom of the Netherlands. Ladies and gentlemen, Mrs. Schwenner.
Thank you, Germaine. Thank you, Germaine, and thank you, Ms. Bonville, for your kind words of introduction. And thank you for inviting me to talk about my perspective today. It's an honor to participate. So on July 5th, an unsolicited opinion on Kingdom, Treaties, and the European Union was published by the Kingdom's Council of State. As per the law, the Council of Kingdom advises on treaties that are being concluded. This is a standard procedure. This opinion was issued because the Council has observed with some regularity that the conclusion, ratification, and implementation of treaties does not always fit well with the structure of the Kingdom of the Netherlands. The Dutch phrase, niet gemakkelijk aansluiten, is used to describe this. It is not always smooth sailing. With this opinion, the Council hopes to be able to contribute to an open dialogue and to a further improvement of treaty practice in the spirit of the Charter of the Kingdom of the Netherlands. Before discussing some high-level pointers of this opinion, let me jump into a comprised summary of the kingdom structure. So we all will remember the slogan, "One Kingdom, 4 Countries." Where does this come from? The constitutional structure of the kingdom, as we know it today, originates after the Second World War. At the time, Aruba, Curacao, and St. Martin were all known as Colonie Curacao. Decolonization was part of that era. The key element in this decolonization process was for the Netherlands to enter into the Charter of the Kingdom of the Netherlands, and that was a long time ago in 1954. This charter created a new legal order for the kingdom. It provides basic regulations to govern the kingdom's constitutional structure. It lays down the division of competence between the kingdom and currently its 4 autonomous countries. The composition of the kingdom has varied over history. Politically speaking, the kingdom is currently composed of 4 countries of equal standing, namely Aruba, Curacao, the Netherlands, and St. Martin. The countries are autonomous. So I have a slide about the fundamental of the kingdom. The next one, yes. Among the fundamental of the kingdom are the autonomy of the countries. The countries manage their own interests independently, and the limited powers when it comes to kingdom affairs, because kingdom affairs are managed jointly with the Netherlands. And then that there is the fundamental that our countries must have a form of government based on the principles of a democratic state governed by the rule of law. The fundamental is compliance with fundamental human rights, freedom, legal certainty, good governance, and this lays with the constituents, so with the countries. And when it comes to the proper fulfillment of this duty by the countries, the kingdom itself acts as a guarantor. That's a so-called waarborgfunctie. So as I said, kingdom affairs are managed by the countries together with the Netherlands, and the competent forum for that is the Council of State, the Council of Ministers of the Kingdom. This is a council consisting of the Dutch Council of Ministers, together with the Netherlands, together with the ministers plenipotentiary of Aruba, Curacao, and St. Martin. Our Caribbean countries have neither a majority position nor a decisive vote in the Council of Ministers of the Kingdom. So then I have a slide of Article 3, and I see that it's on. Thank you for that. It specifies which areas are considered kingdom affairs. And there is, you see that foreign affairs, for instance, is a kingdom affair. And therefore, there is one minister of foreign affairs who has ultimate responsibility for the foreign relations of the kingdom as a whole and for incorporating the interests of all 4 autonomous countries. It's a Dutch Minister of Foreign Affairs as called, but in fact, it's a Kingdom Minister of Foreign Affairs. Since only the kingdom is a subject of international law, only the kingdom can conclude, ratify, and accede to international legal agreements, such as treaties and conventions. The territorial applicability of such agreements may be restricted to, for instance, Aruba, Curacao, St. Martin, or the European part of the Netherlands, but also the Caribbean part of the Netherlands. In other words, such agreements may be concluded by the kingdom for one or more constituent parts. So let's jump to the unsolicited opinion. Please forgive me because I'm going to give a high-level outline of the opinion. If you would be interested to read it, it's uploaded on the website of the Council of State. What's in it? In general terms, a reconciliation is performed with regards to current treaty practice against the legal framework of the Charter, international law, and European law. With respect to international law, I have a slide, the next slide. As noted earlier, the kingdom does make territory restrictions to the applicability of treaties. In general, the basic principle of international law is that treaties apply to the entire territory of the contracting states. But there is the Vienna Convention that have specific rules pertaining to this matter that are outlined on the slide, and it does include some exceptions. The Charter, however, includes 4 countries, and it's there that tension can occur between the 2 starting points. So the Charter at one side, and then the basic principle that treaties apply to the entire territory of the contracting states. But also with respect to the guarantee function of the kingdom. An open dialogue, therefore, is required. An active attitude to this end from all kingdom partners is required as well. And when it comes to human rights treaties and the fundamentals of the kingdom, the general rule is that the fundamentals must first and foremost be promoted by the constituents, so by the countries. The kingdom's role is one of a guarantor. But how does that play out? In its report of 2020, Adviesraad Internationale Vraagstukken requests attention that human rights treaties do not always apply to all of the constituents because the application is sometimes being postponed. And within the Netherlands, it happens that certain treaties only apply to Dutch Netherlands and not to Bonaire, Statia, and Saba. Can different levels of human rights protection for citizens in our territories and citizens with a shared nationality coexist? The Council provides specific recommendations. With respect to the legal framework, and we may be able to jump to the next slide. I have a general procedure outline that goes for treaties in general, the general procedure that will have to be walked through. And when it comes to treaties and the constituents of the kingdom, the relevant legal framework can be found in the Charter, Kingdom Ordinance, and also the issuance of regulations is relevant. As a general rule, Article 27, Section 3 of the Charter stipulates that the constituents should be engaged in an early stage of negotiations when treaties are being prepared that touches, raken, the interests of the constituents as described in Article 11 of the Charter. And with respect to foreign affairs, this article prescribes that the interests of the constituents are being touched if their specific interests are involved or where the provisions contained therein have important consequences, gewichtige gevolgen for those interests. So treaty practice learns that the Ministry of Foreign Affairs works intensively with the respective dienst buitenlandse betrekkingen of the different countries, the different constituents of the kingdom. There is quite some sharing of information within teams, sharing of lists with Parliament, and also other meetings, so-called verdragenoverleg, that is being organized on a regular basis. General treaty practice is that the constituents are being engaged in the provisions of treaties that touches them. The Article 27, as I mentioned, is being applied in that way. General treaty practice is also that the wish of the respective governments of the constituents is being followed with regard to the applicability of treaties. However, the format of working together is being influenced by the different speeds between the Netherlands and the constituents. The small staffs of the Caribbean countries plays a role here. There is limited institutional capacity. This can make it difficult for the countries to follow the ongoing negotiations in all cases and with regard to all subjects, and to provide their input in a timely manner. But it also plays a role when implementing treaties. And this should not come as a surprise. The Caribbean countries are small island states, and the Netherlands, a AAA rated country that is a prominent member of the European Union. As an example, the deadlines to prepare for the decision-making in the Council of Ministers of the Kingdom do not always match comfortably for the constituents to go through their respective internal procedures, including the opinion of the local advisory council, the Raden van Advies. This does not benefit the quality of the country's input. And this all has an impact. Ratification of treaties for the Caribbean countries is put on hold. Other treaties that apply to the Netherlands stay under deliberation. And when it comes to non-compliance with treaty obligations, the kingdom is accountable. But there is more to it. Whether a treaty will be applicable or will have an effect is relevant for the legislative engagement of the constituents as per the charter and the legislative road. So please allow me to elaborate. There are three kinds of treaties that are identified within the kingdom. The ones that only apply to the Netherlands with no effect, the ones that apply to one or more of the Caribbean countries, and the treaties that apply to the Netherlands but with indirect effects for one or more of our countries. In general, if the constituents or one of them decide that the treaty will apply to their country, that usually is because the provisions of the treaty touches the interests of the specific country. However, there are also treaties with territorial restrictions that do not apply but do have an effect. I will further use the term indirect treaties with an indirect effect when I'm referring to this situation. These indirect effects can have to do with geographic relevance, trade or finance, and economic interests of the constituents. But it can also have an indirect effect because it entails rights and obligations for the citizens of the constituent countries who have the Dutch nationality. This part of treaty practice is not always clear. The current primary criteria for involvement of the constituents is whether a treaty touches the Caribbean countries. When it comes to treaties with a territorial restriction that may include an indirect effect, the observation is that this does not always occur. So as a result, no use is made of insights into the extent to which a treaty will work in the countries or has an indirect effect. So more attention should be given, more involvement could also be given by involvement of the Caribbean countries, could also be given by the Netherlands. And there are a lot of possible wins. Insight and involvement give a better position at the negotiation table. And it is at this table that there is room, for instance, to adjust a provision or make a reservation or make a treaty text more in line with what is realistic for the Caribbean countries. The question whether a treaty should apply should be answered earlier in the process, and above all, in my opinion, more carefully. The unsolicited opinion digs further into that. It opines on how to handle the governance and treaty practice. So before looking into the recommendations, let's briefly stop and discuss the situation with the European Union. The treaties of the European Union are only ratified for the European part of the kingdom. Our Caribbean countries, but also Bonaire, Statia, and Saba, have been overseas countries and territories of the European Union for a long time, since 1964, which is a very good year, I have to say. Only a select part of European law applies to OCTs. And OCTs are not a part of the European Union, but are no third-party countries either. The OCT-EU venture has evolved, and so the venture between the member states. Citizens of the Caribbean parts of the kingdom have shared nationality, and based on jurisprudence, for instance, they enjoy the benefits of European citizenship and can, for example, vote in elections for European Parliament. We all may remember the ruling Emancipation. The European Court of Justice has ruled that Section 4 of the European Treaty applies to the OCTs, together with general principles of the European Union. And as we know, we've seen it on the news, I think nowadays, lately, and it's a discussion for a while, the European Union is a community of shared values. This includes freedom, democracy, human rights, fundamental rights, the rule of law, good governance, and sustainable development. When it comes to European treaties, the kingdom, through Dutch government, has restricted applicability to Dutch territory. Can such restriction be upheld under all circumstances? And how should it be weighed against applicable shared values and treaty provisions on union citizenship? And how does it work when rights and obligations under a treaty are linked to the nationality of citizens, regardless of whether they live in the Netherlands or in the Caribbean countries? It is in light of this that the Council opines that even though European law does not fully apply to our countries, its applicability has been steadily growing. Dutch citizens in Aruba, Curacao, and Sint Maarten may avail themselves of rights enjoyed by European citizens. Therefore, our countries should be involved more actively in treaties concluded by the European Union together with its member states. So what is being recommended? And I have a slide. In general terms, more focus, more in-depth working together, more reflection about the core values of the kingdom, more engagement in an early stage of all countries, involvement, attention for implementation, for indirect effects, action, and assistance when needed. For instance, I'm only having a grasp. Set up a procedure in such a way that adequate regard is had to the country's internal procedure and their limited government capacity. Make sufficiently clear how it is determined whether nature and content of a specific treaty make application possible. The timing of such determination can be included in the instruction for the issuance of regulations. And the question whether the indirect effects of a treaty should extend to the Caribbean countries should be examined more carefully. Pay more attention to the question whether the treaty relates to the fundamentals of the kingdom, such as human rights, good governance, and legal certainty. And when negotiating treaties that rely to the kingdom values, extra attention should be paid to the implementation of the specific treaty. Due to the constitutional framework of the kingdom and the autonomy of the countries, they have to make the first move because they know their dossiers. With regards to the indirect effects, indicators are being presented for consideration. So, for instance, treaties that can have a personal effect for citizens of the Caribbean countries can be deemed to have an indirect effect. Bilateral or multilateral treaties with states of American continent or Caribbean, or any other treaties that may have a financial or economic effects for the Caribbean countries. And when the EU enters into a mixed treaty with no participation of the Caribbean countries, analyze whether the effects of that treaty extend to the Caribbean countries, and the outcome should be shared. So now some final remarks. The world and the world order have changed compared to 54. The kingdom constitutional venture has been modified and has evolved. The same goes for the relationship with the European Union. The Netherlands has a strong, robust, and intense relationship with the EU. And although the Caribbean countries still have the OCT position, the influence of the EU shared values has intensified. The recommendation of the Council boiled down to a calibration of the kingdom's compass, both in Europe and the Caribbean. Maybe it has to be replaced with a GPS with precise navigational charts. This calibration, or maybe overhaul, will have effect on international treaties and treaties within the atmosphere of the European Union. It entails sharpening of the governance, awareness, and action. But in my view, there could be more to it. A deeper precision to the kingdom compass or GPS. All of the countries need to preemptively assess their respective internal interests, but also reflect about the fundamentals of the kingdom. The Netherlands and the ministries that are involved are required to delve their knowledge about the interests of the specific Caribbean countries. They need to provide assistance when requested or needed, and the same goes for the kingdom acting as a member of the European Union. The Caribbean countries need to scrutinize their dossiers and interests. They need to substantiate and communicate that within the kingdom, they have to be vocal. It is first and foremost the Caribbean countries that need to monitor international policies and EU policies and see where it has effect and fits in. Hands should be raised, and the Netherlands is in the noble position to assist. And Would this be a good thing? Our countries are small island states, each with their own charm, and on a larger scale, we do well. However, in the context of the contemporary global order, which has changed and is continuously changing, our countries are vulnerable as standalone. The COVID-19 pandemic was a reality check. When threats as climate change and matters such as security are on the agenda, we need to pay attention and take action. The climate transition is unfolding and is real. Both the IPCC and the KNMI reports are sobering. We should continue to assess the kingdom as a constitutional venture, continue to assess our position and ask ourselves, what is the added or strategic value to this venture? Why are the fundamental rights, the principles of good governance and legal certainty stipulated in the Charter our anchors? Does it matter that our countries are part of the common European values and principle? What is the added value for the we, the people, the business community, our stakeholders, and our investors? How can this all add to the interest and well-being of our people? Let's reflect about these existential questions. Thank you so very much for your attention.
Thank you very much, Mrs. Schwenner, for your presentation. Let me introduce you to our second guest speaker of this webinar, Mrs. Viola van Boogaard. Mrs. van Boogaard currently works at the Faculty of Law of the University of Aruba. Mrs. van Boogaard is an associate professor of constitutional law and administrative law and teaches courses on constitutional law, administrative law, international law, European Union law, and human rights. Mrs. van Boogaard is also manager enforcement, market entry, and legal advisory at the Centrale Bank of Aruba. Ladies and gentlemen, Mrs. Viola van Boogaard.
Thank you very much, Germaine, for the introduction, and thank you also for the honor and opportunity to participate in this webinar. I have to apologize in advance because in order to make my point and to bring across my view on the unsolicited advice of the Council of State, there is some overlap with the speech we just heard from Mildred Schwenner. So, but that was, like I said, unavoidable. I gave my speech a title, which is Multi-Speed Kingdom. According to the Charter for the Kingdom of the Netherlands, the kingdom comprises of the countries of the Netherlands, Aruba, Curacao, and Sint Maarten. These countries each have their constitution. The Dutch constitution is the so-called grondwet or basic law, and the respective constitutions of Aruba, Curacao, and Sint Maarten are called staatsregeling, or regulation of the state, if you will. The kingdom itself is an overarching entity that also has its constitution, namely the Charter of the Kingdom of the Netherlands. The Charter regulates its sphere of competence for the kingdom and the countries by listing policy areas of the kingdom exhaustively. For example, defense, foreign relations, and the Dutch nationality. They belong to the exclusive competence of the kingdom. This is stated in Article 3, Paragraph 1 of the Charter. The characteristic of these policy areas is that they concern subjects that are closely related to the unity of the state. Defense is there to guarantee an undivided territory for the kingdom and to protect it as a whole against physical threats from outside. In the context of foreign relations, in other words, on an international level, the kingdom acts as an undivided state when, for example, concluding treaties. Finally, the Dutch nationality accrues to every citizen of the kingdom in the form of one undivided Dutchmanship, Nederlanderschap. In addition to subjects that typically concern the unity of the state, the Charter also assigns a so-called guarantee function, the waarborgfunctie, to the kingdom, which is laid down in Article 43, paragraph 2 of the Charter. This means that the kingdom monitors the realization of fundamental human rights, sound governance, and legal certainty within the countries in the Caribbean. Within the framework of these exclusive powers of the kingdom, the countries can take charge of and regulate all other matters themselves. In this, they are autonomous. These matters which do not fall under the so-called kingdom matters, koninkrijksaangelegenheden, are referred to as country matters, landsaangelegenheden. The Charter thus creates different spheres of interest, namely the sphere of interest of the kingdom as a whole and that of the individual countries. The Charter also instructs the kingdom to take into account the individual sphere of interests of the countries by requiring their participation in the decision-making process as soon as the intentions of the kingdom affect the interests of the countries. Article 11 of the Charter provides a non-exhaustive list of subjects that in any case affect the countries. Article 11 of the Charter provides, for example, that when foreign relations have important consequences for the interests of the Caribbean countries, the sphere of interest of the Caribbean countries is affected. In paragraph 6 of this provision, the governments of Aruba, Curacao, and Sint Maarten are authorized to indicate which other matters affect their country. As soon as a subject affects the Caribbean countries, the ministers plenipotentiary of the Caribbean countries may participate in the meetings of the Council of Ministers of the Kingdom. This is laid down in Article 10 of the Charter. If the establishment of a Kingdom Act for the entire kingdom or the establishment of a treaty is discussed in such a meeting, the ministers plenipotentiary are also authorized to indicate that the regulation should not apply to their country. In principle, the Council of Ministers of the Kingdom must accept the objection to the application unless the unity of the kingdom does not allow this. The Charter thus creates the possibility of a differentiated application of kingdom acts and treaties, and thus creates a multi-speed kingdom. The unsolicited advice from the Council of State, which is central to this seminar or webinar, focuses precisely on the field of tension between unity, uniformity, and disunity or differentiation in the field of foreign relations. Although foreign relations are a kingdom affair, its regulation is not entirely governed by the Charter. Instead, the Charter refers to the Dutch Constitution in Article 5, paragraph 1 of the Charter, and thereby elevates several provisions of the Dutch Constitution to kingdom law. In this case, we are talking about Articles 90 to 95 of the Grondwet, the Dutch Constitution. Article 90 stipulates that the government of the kingdom promotes the development of the international legal order. This international legal order has boomed since the Second World War. In the first place, various international and super-international organizations have sprung up like mushrooms, such as the United Nations, the European Communities, now the European Union, and the Council of Europe. In addition, at the time, mainly unwritten international law was laid down in treaties, including treaty law itself. Treaty law is enshrined in the 1969 Vienna Convention on the Law of Treaties. Finally, human rights have gained a foothold in the international community due to the horrors of the Second World War, and human rights treaties are still gaining in importance. The way in which the kingdom participates on the international plane is to a large extent determined by a Kingdom Act that is based on the Dutch Constitution, namely the Kingdom Act on Approval and Publication of Treaties, de Rijkswet Goedkeuring en Bekendmaking Verdragen. The question that arises here is how the position of the Caribbean countries is regulated in this regard. When we look at the Kingdom Act on Approval and Publication of Treaties, we can read that it expressly imposes the duty on the kingdom to inform the Caribbean countries when a treaty is submitted to the States General for approval. After all, paragraph 3 of Article 2 of this Kingdom Act provides that at the same time as the treaties are submitted, they need to, at the same time as the treaties are submitted to the parliaments of Aruba, Curacao, and Sint Maarten, need to be submitted to the parliaments of Aruba, Curacao, and Sint Maarten if it concerns treaties that affect the interests of these countries. A similar provision can be found in Article 24, paragraph 1 of the Charter. The term affect, raken, herein indicates that it concerns treaties in which the countries of the kingdom have a say in their conclusion in accordance with the Charter. Concerning the involvement of the Caribbean countries in the events of raken, the Charter stipulates that they must be involved at the earliest possible stage in the preparation of those treaties. This is laid down in Article 27, paragraph 1 of the Charter. In addition, they should also be involved in its implementation when the treaty will be binding for them. It follows from this that this involvement of the countries is appropriate when a treaty is given, given its nature and content, will probably be binding for the Caribbean countries as well, and when a treaty will have consequences for the interests of the Caribbean countries without being binding for them. The question that subsequently arises is whether this framework is adequately implemented in practice. Unfortunately, this is not the case. In practice, it appears, as we can read in the unsolicited advice of the Council of State, that only the first consideration plays a role in the question of the involvement of the countries, namely, they are involved when treaties probably will be binding for these countries. The limited involvement of the Caribbean countries I just saw that I was on mute. I don't know, can someone tell me where I got muted?
Yeah, it was only, I think, a few seconds. So.
Okay. So, okay. Could you tell me where I, yeah.
You stated about the limited involvement.
Okay. So the limited involvement of the Caribbean countries in the drafting of treaties is mainly due to the limited capacity of the Caribbean countries to make an adequate contribution to the drafting process. And the limited capacity thus leads to a lack of insight into the implications of proposed treaty provisions, including insight into the enforceability of these treaties. As a result, the countries cannot ask for technical help or assistance, nor are they able to influence the text of the treaty in such a way that the treaty in question remains enforceable for these countries. The advice of the Council of State is therefore an explicit assessment that an explicit assessment is made whether the Caribbean countries can be otherwise affected given the nature and the content of a treaty, and that these countries are actively informed on time when this is the case. In this context, it is also recommended that the regulatory guidance and regulatory roadmap, aanwijzingen voor de regelgeving en draaiboek voor de regelgeving, be amended and clarified with regard to the involvement of the Caribbean countries in creation and adoption of treaties that will affect the interests of the Caribbean countries without them being binding. However, the lack of capacity continues to wreak havoc, especially when it comes to treaties that by their nature should apply to the entire kingdom. Consider, for example, human rights treaties. The kingdom solved the problem concerning the lack of capacity to implement treaties in the Caribbean in a pragmatic way by ratifying treaties only for the European part of the kingdom and only proceeding to ratification for the Caribbean countries once the implementation legislation has already been completed. After all, when a treaty applies to the entire kingdom, and the Caribbean countries fail to implement it and adhere to it, the kingdom may be internationally liable or accountable. In the case of human rights treaties, the kingdom also made reservations concerning the application of these treaties to the Caribbean countries. Since it can have an undesirable consequence or multi-undesirable consequences for the Caribbean countries or the kingdom if it takes too long for human rights treaties or any other treaty for that matter to be ratified, a new paragraph was added to Article 27 of the Charter in 2010 when the Netherlands Antilles were dismantled. I am referring here to the current third paragraph of the Article 27 of the Charter. It provides that if the interests of the kingdom are affected by the absence of regulations or other measures necessary for the implementation of a treaty in one of the countries, while the treaty can only be ratified for that country, if the regulations or other measures are ready, a kingdom decree, or if necessary, a kingdom act may determine how that treaty is to be implemented. In order not to violate the autonomy too much, Paragraph 4 of Article 27 of the Charter provides that if regulations or other measures for the implementation of the relevant treaty have been taken by the country, the Kingdom Decree or the Kingdom Act is withdrawn. The original setup of the kingdom relations according to the Kingdom Charter constantly presents the kingdom with new challenges, because of the ever-growing importance of fundamental human rights and because of the limited capacity of the Caribbean countries to make their voices heard adequately during the drafting process of a treaty. After all, it has been maintained in literature for decades that the guarantee function, waarborgfunctie of the kingdom, as laid down in Article 43 of the Charter, must be primarily seen as an ultimate remedy, ultimum remedium, and therefore as a form of negative supervision that, except in exceptional cases, focuses on ratifying or invalidating decisions already taken. This view places great emphasis on the autonomy of the countries and is a logical interpretation of the context of the great waves of decolonization after the Second World War. However, the incrementally increasing importance of human rights and the associated need for unity in the application of human rights within the same state compel a reinterpretation of the kingdom's guarantee function. An interpretation that does not focus on negative supervision, but which also creates room for positive supervision that goes further than repressive positive supervision in the form of intervention in case of neglect of duties, as laid down, for instance, in Article 27, paragraph 3 of the Charter. This redefinition of the guarantee function not only makes it possible for the kingdom to do much more in terms of preventive positive supervision in the form of instructions, but above all in the form of a stronger coordinating role for the kingdom in the drafting and implementation of treaties. This new interpretation of the guarantee function is applied by the Council of State in its unsolicited advice, as can be seen in the following passage on paragraph 27, and I will cite it in Dutch. De afdeling achter dan ook van belang dat daar waar verdragen zich begeven op het terrein van de waarden genoemd in artikel 43, in een vroeg stadium wordt nagedacht over de vraag in hoeverre deze verdragen hier invulling aan geven. Als de rechten en plichten die uit dit verdrag voortvloeien daadwerkelijk fundamenteel zijn, dan zouden deze als uitgangspunt moeten gelden voor het gehele koninkrijk. Although at first sight this interpretation seems to run counter to the autonomy of the countries, it ensures that the autonomy of the Caribbean countries comes into its own. This is especially true if autonomy is thought in terms of a responsibility for independent management of internal affairs, including the realization of fundamental rights, legal certainty, and good governance. After all, this more active attitude on the part of the kingdom forces the kingdom to provide better support to the countries, as is apparent from the Council's first recommendation. The kingdom should pay more attention to the question of what is necessary for the implementation of treaties in the Caribbean countries. More active technical support from the relevant department and the Ministry of Foreign Affairs is indispensable in this regard. Interesting is the idea that this support actually serves to fulfill the autonomous responsibilities and in particular to support the decision-making process of the Caribbean countries, as expressed in recommendation 4. De landen zouden, waar mogelijk met ondersteuning vanuit het ministerie van Buitenlandse Zaken en Nederlandse vakdepartementen, moeten inventariseren of medegelding mogelijk is. Een dergelijke inventarisatie kan leiden tot het besluit geen goedkeuring te vragen voor een deel van het koninkrijk. Er kan echter ook besloten worden beter aan te sluiten bij de situatie in de Caribische landen door te streven naar meer maatwerk in het verdrag. Bijvoorbeeld door het maken van voorbehouden in geval dat verdrag dit mogelijk maakt. This idea of supporting the autonomous decision-making process of the Caribbean countries is also reflected in recommendations 7 and 8, where the kingdom provides support when considering whether the countries are affected or touched within the framework of the treaty. Ultimately, this approach forces the kingdom to adopt institutional empathy. In this context, I will only refer to recommendation 10, in which the Council of State proposes to pay attention to the advantages and disadvantages of including parts of the mixed EU treaties for the Caribbean part of the kingdom when performing the future evaluation of the relationship of the BES Islands, so Bonaire, Statia, and Saba, with the EU. Ultimately, the Council of State seems to confront us with the counterintuitive possibility that more intensive cooperation between the countries and the kingdom will not only help to achieve autonomy, but also that this cooperation will ultimately increase the capacity of the countries and thus will help increase their autonomy, as is expressed in recommendation 5. In het proces van verdragsonderhandeling en goedkeuring zou meer acht geslagen moeten worden op de relatie tussen het verdrag en de waarborgfunctie. Hierop zou ook in de toelichtende nota bij de goedkeuringswet moeten worden ingegaan. Dit vraagt een actieve houding van alle koninkrijkspartners, waarbij allereerst de landen zelf aan zet zijn. Hiervoor zal gezamenlijke, institutionele capaciteit moeten worden opgebouwd. The consequence of such an approach, as proposed by the Council of State, is not a one-speed kingdom will be created, but a kingdom with multiple speeds that are better attuned to each other than is currently the case. The focus here is on more unity, more harmony, and less autonomy, and less on autonomy and dissonance. I would like now to go into an example with respect to a human rights treaty or human rights protection. Because on January of this year, during the Vierlandenoverleg, four-country justitieel Vierlandenoverleg, the four-country justice consultation, if this is a correct translation, between the four ministers of justice within the kingdom, a inter-country project was approved with the aim of establishing a consensus kingdom act that should lead to a harmonized level of protection within the kingdom in the field of personal data protection. This aspect of the right to privacy, data protection, has received a lot of attention since the introduction of the General Data Protection Regulation of the European Union on May 25th, 2018. After all, this European legislation has not only had consequences for data protection within the member states of the EU, the consequences of the GDPR were felt outside the EU in the exchange of data with so-called third countries. In the Schrems II case of the European Court of Justice, the privacy shield for data exchange between the US and the EU was annulled, as it did not provide sufficient guarantees for the protection of personal data under the GDPR. For the transfer or exchange of personal data to the US and other countries that offer a lower level of protection than the GDPR, so-called binding corporate rules or model contracts that guarantee this level of protection must be used. The kingdom is a member state of the EU, but only the European part of the kingdom is bound by EU law in its entirety, and thus also by the GDPR. The result of this is that the exchange of personal data within the kingdom between, for example, judicial authorities has become a lot more complex. After all, the Caribbean countries, but also the BES Islands, have a special association with the EU as overseas countries and territories, and therefore do not fall under the scope of the GDPR. The level of data protection in the Caribbean countries is now many times less than in the Netherlands. Aruba is the furthest behind in this respect. Aruba currently only has the state ordinance on personal records, Landsverordening persoonsregistraties, which in terms of content is comparable to the old Dutch Personal Records Act, Wet persoonsregistraties, from 1989, which was replaced in 2001 by the Personal Data Protection Act, Wet persoonsgegevensbescherming of bescherming persoonsgegevens. The level of protection in Curacao and Sint Maarten is comparable to this old Personal Data Protection Act from the Netherlands that was enforced in the Netherlands until the introduction of the GDPR in 2018. In the BES Islands, the BES Personal Data Protection Act is in force, which is also comparable to the state ordinance in force in Curacao and Sint Maarten and the old Personal Data Protection Act in the Netherlands. A salient detail is that the current Convention for the Protection of Individuals concerning the processing of personal data of the Council of Europe, the so-called C108, only applies to the Netherlands and since 2010 also to the Caribbean Netherlands, so Bonaire, Statia, and Saba, but not for the Caribbean countries within the kingdom, so it doesn't apply to Aruba, Curacao, and Sint Maarten. In the Caribbean, Bonaire, Statia, and Saba are at the forefront of personal data protection. For the Caribbean countries to be fully up to speed concerning the level of protection of personal data required by the EU, considerable catching up is required, especially when we want to exchange personal data. However, given the letter from the Minister of Justice to the State General of September 2nd, 2020, it was not only the intention for the Caribbean countries to strive for a level of protection under the current Data Protection Convention, C-108, which is mainly principle-based and technology neutral. No, they want to bind the countries directly to a modernized version of their treaty. So, including the amendments according to the new protocol of October 10, 2018, the so-called C-108 plus. The modernization had two goals in mind. First one is to deal with challenges resulting from the use of new information and communications technologies. And the second one is to strengthen the convention's effective implementation. This new protocol is expected to enter into force on October 11, 2023, provided at least 38 states have ratified it by then. Given the outline memorandum of the envisioned Consensus Kingdom Act, the modernized Data Protection Convention, C-108+, is the starting point. In addition, aspects of the GDPR will also be included, such as how it deals with the processing of personal data and the transfer or exchange of personal data to third countries and international organizations. The project group also wants to include the rights of data subjects for data portability and the right to be forgotten, which are included in the GDPR, but not in the C-108+ convention. Naturally, also a system of legal protection must be provided, as is laid down in the C-108+ convention. Finally, it is also the intention that a supervisor is established at an appropriate level of protection will be guaranteed. And the C-108+ also demands that the supervisor can deploy administrative enforcement means to enforce compliance with the data protection level that is needed. To bring this ambitious project to a successful conclusion, an inter-country project group has been set up, which is led by the Kingdom or the Netherlands, and in which the countries of the Caribbean are also represented at an official level. It is a very good and important initiative because data protection has become increasingly important, especially during a digital age. Nevertheless, I cannot, I get the feeling that although this concerns an inter-country project, and that will be regulated in a Consensus Kingdom Act, it seems that it is disguised as a kind of application of Article 27, paragraph 3 of the Charter. After all, the Kingdom has already signed the C-108+ Convention on October 10, 2018, but has not yet ratified it, not even for the European part of the kingdom. The aim is to have this Consensus Kingdom Act in place well before October 11, 2023, so that the kingdom can ratify the protocol in time for the whole of the kingdom. The question that remains is to what extent the interests of the Caribbean countries have been considered in the negotiations of this protocol of the C-108+ Convention, and to what extent they have been involved in the drafting of this convention. In other words, to conclude my speech for today, I believe that the application of the recommendations by the State Council will be a great step forward to ensure better guarantees for the Kingdom countries with respect to also their autonomy. Thank you very much.
Thank you, Mrs. van Boogaard, for your excellent presentation.